Hi, this is Professor Opterbeck, and in this video we're going to break down the EU AI Act on the definition of high-risk AI and on the human oversight requirement for high-risk AI. So let's first look at the definition, which you can see is actually not in the definitional section of the Act, which is a little bit confusing. It is in Article 6 of the Act. And when you parse through this, you'll see that there are two different broad components to this definition. So the first is certain kinds of products or services that are regulated under different health and safety regulations within the EU. Those various health and safety regulations are listed in an annex to the EU AI Act, which is Annex 1 to the Act. Now for these Annex 1 type products, the AI Act gives us a two-part test. So is it an AI system that is intended to be used as a safety component of an Annex 1 product? Or if the AI system itself is the product listed in Annex 1, and is that regulated product required to undergo a third-party conformity assessment under the relevant regulation? So you need to have a little bit of a feel for the background for the way the EU does health and safety type regulation for certain kinds of products. So the regulations will give different kinds of specifications, things that are permitted, things that are not permitted, things that are required for that product, and then it will have a process to obtain some kind of third-party review to certify that the product or service is in conformity with the health or safety regulation, and then often a way of kind of registering that you've received that certificate of conformity. We'll see actually that the AI Act does something similar with AI, including with high-risk AI. So you've got to, if the product meets those requirements, and you'd have to then dig into the specific regulation to see if the product is covered and if there is this third-party conformity assessment requirement. Now notice also that this section will apply regardless of whether the AI system is put on the market independently of the product or service. In other words, if the AI system is a safety component that is built into the regulated product or service, then this will apply, as well as whether it is independently the product itself or independently a safety component that's distributed with the product itself. So the first part of this definition is what I'll call a AI component, safety component of an Annex 1 product or service, or AI as the Annex 1 product or service. The second part of the definition is a specific list of AI capabilities or functions listed in Annex 3. So Annex 1, a regulated type of product or service. Annex 3, a specific list of AI components or functionalities. Now, if you fall, it's very possible your product or service might fall under both Annex 1 and Annex 3. Obviously, in that case, it's going to be considered high risk. It might fall not into Annex 1, but then it might fall into Annex 3, even if it's not one of those kind of specifically regulated, related to one of those specifically regulated products or services. So now let's take a look at Annex 1 and what kinds of products or services are regulated there. Now you really have to look at Annex 1 to see the full list of all the specific regulations that are given, but I've tried to distill this and break it down a little bit. And when you look at this list, it probably will make some sense as to why these kinds of things might be subject to some kind of health and safety regulation. In the US, we have health and safety regulations both at the federal level and at the state level regarding these kinds of products as well, although in the US context it's likely to be piecemeal under different kinds of statutes, under different agencies, where the EU approaches to have a directive or a regulation that applies to each of these in maybe a bit more of a unified way. But if you look at this list, it makes some sense. Machinery, toys, recreational watercraft, lifts, that is elevators, explosive atmospheres. This can include, for example, mines where the mining gases might explode, radio equipment, pressure equipment, cableway installations, personal protective equipment, gas appliances, medical devices, in vitro diagnostic medical devices, aviation security, motorcycles, tricycles, agricultural vehicles, marine equipment, rail systems, motor vehicles and trailers, aircraft, including aircraft engines. So all of these kinds of things, as noted, would be regulated in different ways in the US, regulated under specific rules in the EU. And if the AI system is a safety component of any of these things, or if the AI system is the product, that product itself, then it's going to be considered high risk. Now, notice a couple of these, for example, medical devices would be in the US regulated by the FDA, but this is an example where a medical device or a diagnostic medical device could actually be software, just software. And in the US, we have regulations about software as a medical device, SAMD. So that's just an analog of how the EU is doing it. So what about the Annex 3 systems? And again, if you need to look at Annex 3 and see kind of specifically how these things are defined, but this little bit of a list will give you a feel for it. And if you look at this list, I think, again, it will make some sense about why the EU considers these kinds of applications to be high risk. So biometrics, safety components of critical infrastructure, digital and physical infrastructure, assessment, evaluation, monitoring in the educational context, assessment, selection, monitoring, and so on in the employment context, essential private services and essential public services. Eligibility, creditworthiness, underwriting. So you can see by essential private services, it's referring to things like insurance or lending, mortgages, and things like that. And public services, things like emergency response. Law enforcement, a variety of applications, whether someone's likely to be a victim, whether they're telling the truth, something analogous to a polygraph in an AI kind of setting, investigating and prosecuting criminal offenses, profiling. Now, we noted this in our prior video. This is an area in which the EU AI Act is encompassing things that in the US would be considered elements of criminal procedure under constitutional law. So, of course, there are sort of quasi-constitutional or treaty-based human rights provisions in the EU broadly and in the member states that would cover this as well, but we see the EU AI Act bringing this AI context into the Act. Assessment and polygraph type things, application procedures in migration or asylum, and then in the administration of justice, judicial process, and the like. So you can see these are domains of education, of employment, of access to civil services, of access to important private services like insurance and credit, critical infrastructure, and then the judicial system, law enforcement. Now, if a system does fall into one of these categories in Annex 3, the provider can obtain a derogation, that is an exemption or an exception from considering the system as high risk under Annex 3. And there's a process for doing that outlined in Article 6, Paragraph 3. So notice that the basic test is a kind of balance test. There is not a significant risk of harm to health, safety, or fundamental rights of natural persons, including by not materially affecting the outcome of a decision. And then there are a number of specific things that are listed here that would satisfy that definition. So narrow procedural task, improving the result of a human activity, detecting patterns or deviations from prior decision-making patterns, and just a preparatory task for the purpose of assessing a use case under Article 3. So these kinds of things would be considered derogations, in other words, are exempted. Derogations cannot apply under Article 6.3 to anything involving profiling, and even if the provider is claiming a derogation, they have to do a formal assessment to demonstrate why the derogation applies, and they have to register the product in the same way that a high-risk product would have to be registered. And we're going to look at that registry a little bit later in the semester in another video. And they've got to file that assessment with the registration. So you might ask, well, why would you ever want to do a derogation? Well, we'll be looking at many other requirements that apply to high-risk systems. And if you have a derogation, you don't have to comply with all of those other requirements. Now, of course, if you claim a derogation and you register your assessment, and the enforcement authority looks at your assessment and later claims you are incorrect, you might find yourself in kind of a regulatory problem. So this is going to be something that providers are going to have to make their own kind of internal risk assessments, their regulatory risk assessments of whether they want to try for a derogation or whether in fact they want to go ahead and just make sure they're in compliance fully as if it were a high-risk system. Finally, in Article 7, there is a provision for amending Annex 3. And there's kind of some lengthy text here about a balancing test that the European Commission can apply. But what it's basically saying is that the Commission can, at its own initiative, add categories of things to Annex 3 as a balancing test warrants that. Now, once something is determined to be high risk, as noted, a number of regulatory requirements kick in, and the one we're going to focus on right now is in Article 14, which is human oversight. And as we have said, human oversight is one of those fundamental AI ethics principles. So what does human oversight mean in Article 14 in the EU AI Act? Well, this is a bit tautological, but human oversight means that the system can effectively be overseen by a natural person when it is in use. And this can be accomplished through a variety of ways, including through a human-machine interface tool. In other words, through something in the user interface that allows the developer or the deployer to accomplish what has to be accomplished. The human oversight has to be able to minimize risks under conditions of reasonably foreseeable use. So there could be some kind of possible extreme use case that might put it outside of this zone, but the reasonably foreseeable use. And it can include, and in fact, I think the Article 14 is meant to incentivize including human oversight by design. Now, in the privacy space, we speak of privacy by design. So one thing that the GDPR and other comprehensive privacy regulation and sector-specific privacy regulation is trying to do is to say, when you're building that system or product, design in the features that are going to enable privacy, right? So design in ways in which users are presented with the information about what data is being collected and how they can opt in or opt out and how they can retrieve the information and so on. So similarly, the AI Act as a whole, and this section in particular, is incentivizing AI compliance by design, and in this case, incentivizing human oversight by design. So build into the system, to the extent you can, these capacities for a human being to do this. And in particular, Article 14 says that the deployer, that is the person who's putting the system into use, right, the entity who's sending the system out to be put into use, has to be able to understand what the system is doing, has to have some ability to notice if there are biases creeping into how the system is running, has to have the ability to intervene in the operation of the system, to choose not to use the system in some context, whether it's making a decision or whether it's a safety override, and to be able to override or turn off the system. So notice this is not just a human person who's kind of in the loop merely observing, but a human person who's able to observe, right, and intervene, modify, turn off, override. All right, so that's our summary of what a high-risk system is under the EU AI Act and what human oversight under Article 14 requires for high-risk systems.